guess my question was why it's so long.
Oh, very easy to answer that. And it was funny when you mentioned that as a question. The reason it takes so long is, one, our court system is very antiquated.
As you can tell from our website, America has come a long way in balancing the needs of the individual and the values of the community as far as the death penalty is concerned. This is not to say flaws in the system do not exist. The most problematic of these flaws is the slow pace at which the judicial system arrives and follows through with this final verdict on death sentences. This slow and drawn-out process harms both the individual and community, detracting from the death penalty's potential value and initial intent.
It might seem like the police and the courts drag criminals to jail or sentence people to death awfully quick in cop shows. However, this representation couldn't be farther from the actual American judicial system. Today, felons spend an average of 10.3 years on death row. This time would be a lengthy prison sentence, much less a time spent waiting to die.
But what makes this process so long? Many factors contribute to this lengthy process. When an individual is initially convicted of a felony, a state court tries him or her. As soon as the death penalty becomes an option in the hearing, the case is immediately tried in the state Supreme Court, bypassing the state Court of Appeals. Two juries then hear the case, a convicting jury and a penalty jury. This takes about 2 years. A judge must then approve a jury's decision to use capital punishment. However, a judge can choose to shelve the case for as long as 10 years, a period in which the case goes untouched until the next judge decides to take the case on. After a judge's approval, the criminal can then file for an appeal, arguing errors in the minutes of the initial trial that happened years ago. This appeal means new lawyers and new arguments. Each appeal can take years, and California's average conviction to death takes 22 years. But why would an appeal take so long? The bulk of the time during the appeal process is actually spent waiting.
It's supposed to be 2 years on the federal side, turns into 10. And there's it takes 10 years on the state side too, because there's not enough people to defend these individuals on appeal, right? The state doesn't pay lawyers enough. They pay them $65 an hour. There's not a big enough pool, so what happens is sometimes it takes a couple years to get the case ready for appeal, and then it takes 3 or 4 more years just to get an attorney. Then they have to write the briefing. That takes another year to 2 years, and the responding briefs. And by the time you get through oral argument, you're looking at 10 years on the state side.
So where did this slow system come from? In the past, the speed at which criminals were convicted was often measured in months rather than years. The process began lengthening in 1972 in Furman v. Georgia, when the Supreme Court ruled the system too hasty and unequal. The Supreme Court ruled that until the states could improve the system, the death penalty was illegal in the United States. Within 4 years, the states created today's modern-day death penalty process.
Prior to Furman, it was one jury deciding everything. It was like the garbage can scenario. Everything went in. They said guilty, death penalty. So there was no separation. There was no independent consideration. So they built in the 2 phases. They built in aggravating versus mitigating and the whole weighing process.
What's wrong with the slow process? A process that is slow and indecisive harms both the individual and the community in multiple ways, straying from the initial intent of the death penalty.
Firstly, the lengthy sentencing time makes the judicial system appear weak and indecisive from the public's perspective. The eager community seeking decisive jurisdiction loses faith in the government's ability to administer punishment. If the state waits decades to perform an execution, then the community as a whole sees the death penalty as weak. Therefore, the community will not feel emphasis on the value of life that the death penalty initially intended to promote. Furthermore, a death row inmate, because of his or her need for individual attention, costs the state $90,000 more than a regular prisoner serving time. This money inevitably comes out of the community's pocket. Not only does the lengthy process bode unwell for the community, but also for the individual on death row.
Criminals on death row spend 23 hours a day, 7 days a week in solitary confinement.
The idea of death row is to separate out those individuals who have committed capital crimes, primarily because they're thought of as the most dangerous individuals. So death row inmates are removed from the general population. They are on lockdown 22, 23 hours a day. They basically get out. They do not intermix with other prisoners. It's a very solitary life.
Such living conditions are subhuman. This lifestyle, sustained for up to 22 years, causes severe psychological problems.
Loneliness is very much like pain. It was evolved over time to change our behavior so that we reconnect with others, which is necessary for our survival.
Even in prison, inmates interact with others on a constant basis. However, death row inmates have no one for decades upon decades. This slow process unfairly punishes a death row inmate beyond his sentence, taking an excessive toll on the individual convicted.
Perpetrators in prison spend years waiting to be free. Perpetrators on death row spend years waiting to die. Beyond confinement, individuals on death row live a transient life of fear, adding to a list of punishments not included in a death penalty sentence.
The original intent of the death penalty is to balance the needs of the individual and the community. We see that through a drawn-out process, the judicial system detracts from the initial intent of the sentence by harming both. However, by streamlining this judicial process, we can work to restore the initial intent of the death penalty in America.